Hello there from Jerusalem, Israel's capital, my home, and the seat of the Supreme Court of Israel. I'm so pleased to address my friends at UCLA Nazarian Center for Israel Studies. I remember very well my visit to your campus only 2 years ago, and I look forward to seeing you all again in person. I also welcome you to visit Israel Democracy Institute on your next visit to Jerusalem, to Israel. Well, in all democracies, the relationship between the branches of government is delicate. This is especially true in Israel, where the Knesset, the government, and the Supreme Court are engaged in a struggle over power and principle. The reality has placed our judicial system in a dangerous position. On the one hand, our justice system is appreciated around the entire world. On the other hand, public trust in the court decreases. This decline is partly a result of an ugly campaign by politicians. But I believe it is also a result of the court's willingness to make sometimes necessarily unpopular decisions. My solution is to pass a new basic law that defines the relationship between the court and the Knesset, the Israeli parliament. Today, together with Israeli leading legal scholars, you will have the opportunity and the chance to discuss the challenges we face and highlight the vitality of Israel's democracy. Thank you so very much to the Nazarian Center for hosting this event together with the Israel Democracy Institute. I wish you all a fruitful discussion and, of course, blessing from Jerusalem.
Hello, everyone. Having President Rivlin open this event is a hard act for me to follow, but I'll try. I want to welcome you all to this special event brought to you by the UCLA YNS Nazarian Center for Israel Studies, together with the Jerusalem-based Israel Democracy Institute, a non-partisan center of research and action dedicated to strengthening the foundations of Israeli democracy. This event is also co-sponsored by the UCLA International and Comparative Law Program and the UCLA Levy Center for Jewish Studies. I'm Dov Waxman, the Rosalind and Arthur Gilbert Foundation Chair of Israel Studies at UCLA and the Director of the Nazarian Center. And it's my great pleasure to introduce our speakers and to serve as the moderator for our discussion today about the challenges currently facing Israel's Supreme Court. There will be two parts to this discussion. First, I will talk with Justice Dorit Beinisch, who was a justice on Israel's Supreme Court and the president of the court from 2006 to 2012. The first woman to be president of Israel's Supreme Court. As a justice, she ruled in numerous cases relating to human rights, minority rights, terrorism, and national security. With her decisions, she made significant progress in protecting the rights of women and children that led many to compare her to the late Ruth Bader Ginsburg. Before serving on the Supreme Court, Justice Beinisch was Israel's first female state attorney, and since leaving the court, she has been the governor of the Open University in Israel. After my conversation with Justice Beinisch, I will talk to two Israeli legal scholars, Professor Yuval Shany and Dr. Manal Totry-Jubran, who I will introduce later. Finally, after my conversation with them, I will put to them questions from the audience. So please send us your questions using the Q&A box. Now, without any further ado, I'd like to welcome Justice Beinisch. Justice Beinisch, thank you so much for joining us today. As you heard in President Rivlin's opening remarks, there is a decline, there has been a decline in the trust that the Israeli public feels towards the Supreme Court. The Israel Democracy Index, the latest democracy index from the IDI indicates that this trust has declined, particularly among right-wing Israelis. Why do you think this has happened? And how do you think the Supreme Court can restore its public standing?
First, thank you for the introduction. And I must say, I am not that disturbed or worried about the decline, because I think that you have to know the Israeli background, how historical and cultural background, to understand also the attitude and the trust of the people in the court. So what we see when we analyze the report as to the trust of the people, few things I must say. First, in the last decades, in all the institutions of the state, there is much less trust. People, you know, when we started years ago, everyone said, well, if the government says, if the court says, it's okay. This naive background has changed everywhere. This is one thing. The other thing, when you analyze what the report brings, the information, the details, especially, and you mentioned it already, the right wing, Haredim, ultra-Orthodox, and religious, and people from religious parties. This is how they analyze the trust in the court. Well, there are many reasons. First, our President Rivlin already mentioned a lot of political, I would say even incitement against a campaign against the court. I'll try to explain it later. So this is one thing. The other thing is, you know, from the beginning, from the establishment of the state, the idea, what is a Jewish state, is not in our consensus. We have always stated that we have two norms, basic norms for our existence as a state. A Jewish state, whatever it means, and a democratic state, whatever it means. This, at least with the Jewish population, is a consensus, but there is no consensus. What is a Jewish state? This group of religious parties, Haredim, they, from the beginning, wanted that the law of the halacha, the religious law, will be the law of the country. This was not accepted by the founding fathers of the state because it's a secular state from the beginning that adopted Zionist values for Jewish culture, for Hebrew language, for everything that we have in common in society. But this is not, the law of the country is a secular law that the Knesset adopted and not the halacha, and they never accepted it. I mean, we have, of course, we have religious justices in the Supreme Court, not the mainstream of the, also of the religious people, and accepted it. But the Haredim never wanted, the ultra-Orthodox never wanted to take part. Although, you know, when they're in trouble, they come to the court with petitions. So this is how it works. And the other thing, which was mentioned, really, it's unbelievable what we are going through with the idea, what does a democratic state mean? Some of them, of course, the right-wing parties say, we were elected, you were not. You know that from the states too. If we were elected, we will decide. Who is the court to decide for us? So this is one of the serious problems. What is the governance of the state? Is it only a majority rule, or is it also democratic values? The court represents also democratic values, human rights, which means, and also rights of minorities, separation of power, the rule of law. Not everything is accepted. They say, we were elected, we are the majority in Knesset. This was the idea. And that's why the court should be much less strong. Well, you know that the Israeli Supreme Court has really prestige, always had in the country, and not only in the country, because of being very independent, really not following exactly and more than exactly orders from anyone. And this is the power of a democratic court. If it's not independent, it's not a democracy. So this is also a cause for tension. Politicians look to the court as if it is an institution that wants to have more power, which is really not true. But this is the only language that politicians understand. And the idea that the court and the courts in the Supreme Court is not looking for power, but for implementing certain values that represent our democracy, is not always accepted. So this is part of the tension that exists. Kind of tension, I don't have to say it, exists everywhere between branches of government. This is once a court has the power to review, judicial review, those who are reviewed don't like it too much. So this is a very natural tension. In a society like Israel, which is so polarized with so many fractions and really different ways and extreme groups, it's even more complicated to keep the role of the court in consensus. One of the things that are now, it's an issue that I can imagine that we will talk about it, is do we have justices that support the right wing or the left wing? Something which is not really typical to the construction of the Israeli court. It wasn't like that. It's again a kind of political interference. So this is part of the background. Still, if you see the report that you mentioned of the ideas about democracy, the report, you can see that still now, after the decline of the trust, as they say, first place is the military, the army. Second, the president of the state, which was the president we just heard now. And third is the Supreme Court, higher than other institutions, other than the Knesset, the government, the media, is still the Supreme Court. So I don't accept this outcry of the decline. It's not optimum, but it's not that bad, in spite of what's happening around us.
Well, I think that's an important perspective, and I appreciate that. I mean, it's certainly important to bear in mind some of the perennial issues that have faced the court. And as you mentioned, the attitude of ultra-Orthodox Israeli Jews hasn't really changed fundamentally toward the court, but the attitude, it seems, of right-wing Israeli Jews, it has shifted somewhat. And that's partly because of these, really, it seems to me, as an outside observer, unprecedented political attacks. I mean, to take just a very recent example, the Likud Knesset member David Amsalem's kind of attack against the Supreme Court.
There is an attack.
Do you think these kinds of attacks are unprecedented? I mean, is this a new development? And if it is, how can the court respond to this? I mean, does it just have to kind of stay quiet while it's being essentially delegitimized?
Well, it is a new phenomenon. I mean, it's a process. I already talked about it, I think it's about 10 years ago or more. It started then and even earlier because many political issues come to the court. The court is apolitical. The decisions are professional. But you know, when someone is not happy about the result and some are not happy about the results, it started to get an interpretation of a political court, which is really not true. You know, there were days that we didn't even know, because of the system of appointing judges, we didn't even know to what party did someone vote when we used to watch election results together, and we didn't know who is happy and who is not, because we never discussed it in the court. But there is a background, of course. Every justice comes from his background or her background. So you can see who is more considered liberal or not. But what really opened this is that the court, since 1980, actually, opened the court, access to the court, not demanding the rule of standing, not the right of standing, which meant that everyone has access to the court. This is something that politicians didn't like so much, especially, again, right wing, for many reasons, because when different NGOs and people came to the court as to the legality of or infringing rights of people, population, Arab population, working migrants, this kind of things, the politicians didn't like it. So this opened, and this gave the court the label of activist court, which actually I think it's exaggerated. But it is true that the court had open doors, not demanding the right of standing. This changed the attitude from inside the country and also politically. The other thing is that we didn't accept the non-justiciability principle, which again means that the court could review every decision. It doesn't mean that it happened or that the court interfered, but it gave again access to the court. Politicians didn't like it so much. So now when we see what we call changes from members of the right wing, the demand changes in the court's jurisdiction, they want again to abolish this open door policy of standing, open standing. And this is part of what we see and feel in this controversy.
Yeah, it's very interesting. I think for an American and international audience who may be unfamiliar with this open door policy, and it's interesting when we think about the challenge to the Supreme Court in Israel, many people point to the kind of judicial revolution that that Justice Barak initiated in the 1990s, but you're suggesting that actually the shift in a way and the challenge started earlier when the court adopted this open door policy. Can you just say a little bit about that? Because it really distinguishes, I think, the Supreme Court in Israel and also the vast number of cases that you hear as a justice from, say, the Supreme Court in the United States.
This is not the only reason. The system is really very different, and I cannot elaborate in a nutshell. We are talking now. So what they call the revolution is not that great revolution. As you know, Israel was founded without a written constitution. And what we call the Barak's revolution, constitutional revolution, meant that certain legislation that contradicts the basic law of dignity and rights, if it is not obeyed, not respected, the court could review the legislation. This was the real thing that they call the revolution. Actually, the court followed Marbury versus Madison, that even if it's not a written jurisdiction to review legislation, it is natural because of the clauses of the human rights basic law. But I must say that I'm not sure that this was the real true against criticism against the court, because the Knesset, the interference was very, very rare and very, most of the time, not even basic important norms. The government didn't like the criticism, the review, in regular review of administrative decisions, of the government decisions. So it started, that's why I say it started in the 80s and not in the 90s. This was kind of a development, an excuse to criticize the court, but it started much earlier. And this is the demand of the Knesset now, those who demand it, to really make it again narrow, not to bear the access to the court, which can be a catastrophe, because this is the tool to review corruption, because if everyone can come to the court with this, to the court, has access to the court, if NGOs can see to weak groups and see to their fate, this is so important that I hope that this will never happen. Another thing is, of course, because of the lack of a written constitution, we still don't have very basic rules how to review legislation. What are the rules to legislate? This is something, and I think this is also the basic law that President mentioned, that should be legislated constitutionally. This is something that we are fighting for years. So I hope the day will come that it will happen.
So it's interesting, just to follow up, I think, the focus of concern around the world, at least in the United States, with regards to the challenges facing the Supreme Court has been this kind of the attempt or the talk about passing some override bill, which would allow the Knesset to override Supreme Court decisions. But if I'm hearing what you're saying correctly, in many ways, do you think that the greater threat is this narrowing of the court's jurisdiction, that preventing many petitioners from even getting access in the first place?
The override, this is the demand of many members of Knesset and government officials. If we want a basic law of legislation, this is something that we want very much. And then the review of legislation will not be interpretation of the court, as I said, the Marbury Madison rule, but enshrined in basic law. The condition that they put is the override. Now, the override, in my view, is a technique and a tool that doesn't suit the Israeli reality. I mean, you don't see many countries that have this rule. It exists in Canada, but they never, in the federal system, never used it in Canada. In provinces, yes, not in the federal system. I can assure you that if we have just an override clause in our legislation, almost every decision could be, abolished by the Knesset. So if we accept in certain conditions the rule of the override, the notwithstanding rule, it should be with very special specifications so that it will not be a routine to override court decisions. And this is one of the issues of legislation that is now very, very important and discussed also by the IDI and other institutions and of course Knesset members.
So we're talking about Israel's basic laws, and you mentioned one of the the law on basic law on human dignity and freedom. I think that was passed in 1992. More recently, in 2018, of course, there was the passage of the nation state basic law, Israel as the nation state of the Jewish people. How do you think these basic laws have shifted how or impacted how the court has tried to balance, if you like, Israel's Jewish and democratic nature, and the balance as well between individual rights and kind of collective rights, if you like, in Israel? Has it, in this kind of constant balancing act that justices on the court have to do?
Well, the basic law that we mentioned a few times of dignity and human rights and freedom, this basic law, we particularly cited, that's the first paragraph, that this is to protect the values, the norms of Israel as a Jewish democratic state. So to interpret this term, what is a Jewish and democratic state, became a judicial issue. The interpretation of the law, part of it is what does it mean, judicial and democratic? Of course, many say it's a contradiction. We always believe that we can harmonize and we have to harmonize with our interpretation the basic values of Jewish law and democracy. And this is not exactly, doesn't have to be a contradiction, because the basic rights that are in the law, in the basic law, are acceptable also according to Jewish tradition. Human dignity is a Jewish value, not only a democratic value. So the court tries to combine, not an easy role, but this is the role of the court since this legislation. I don't know if the balance shifted. This is what they try to do, many, again, politically, not the court. You will have a discussion about the national, later, I understand, national basic law. until now, I think the court very carefully interpreted the law so it will be part of, actually didn't change and didn't give the Jewish values a preference on the democratic values. This is according, as I read, the interpretation of the court to that law, and we didn't see any other implications until now in legislation or in judgments, actually. I hope it will be like that. You see, politically, you could argue, do we need this law? Because Israel is a Jewish state according to the Declaration of Independence, accepted like a Jewish, was born like a Jewish state, which meant homeland for the Jewish people. It didn't mean, as I said before, a Jewish religious state or whatever it means. This is part of our discussion all the time. So you could say that we didn't need that law. Anyway, it was accepted as a basic law, enacted, and the court until now gave the interpretation, in my view, that could be together and understood together with all our former judgments and values that we gave them power in our judgments.
So I have time for just one final question, and we've talked so far about really within the Green Line, and of course the Supreme Court has also made many decisions regarding Palestinians in the West Bank and the Gaza Strip, and I would like you to just, how do you see the court's role in terms of protecting both the human rights, civil rights of Palestinians, particularly in the West Bank? Does it have has that shifted at all? And how would you respond to the criticism that the court hasn't done enough to protect the rights of Palestinians in the West Bank in particular, and Gaza Strip as well?
No, Gaza Strip is not anymore under our control. There are problems, but not anymore of this kind because we don't rule the territory. There are other arguments against the relations, but it is controlled by Hamas. But the court, and this is a very special and unusual situation, of course, because as you know, the Israeli law doesn't apply and the territories remained under international law of occupation, which is of course not a normal situation for so many years under the law of occupation. But when the court decided since the beginning of that keeping the territories, that people from the West Bank, Judah and Samaria, will have access to the court, which was accepted. This was, of course, the power of the court to protect and to try and strike the line between security needs and of course, human rights. This is not a perfect situation to say, this is an understatement, I must say, because the problems are very serious. And to keep a regime which is different with legislation than our regime in the country is really problematic. But the legal interpretation of keeping the territories, and until now it remained, from the legal point of view, temporary, which is a long temporary, but it is temporary, which means things may and can be changed if the political background will allow, and it will be possible to change it. I hope so. So anyway, with this, if you ask what did the court do? Again, the court doesn't initiate cases. Cases that come to the court are adjudicated in it, but not the initiative of the court. And I think that the court did a lot, especially during times of really wartime or times that there was a lot of tension, military means were taken, and the decision, and sometimes, and we had especially times of the Intifada, also here, And to strike the line between the military needs and still protect the population, which has the right to be protected according to international law, wasn't an easy task. I think we did a lot, but we didn't solve the problem. So you can say that both sides, right and left, are not very happy about decisions of the courts. But the court is one of the institutions of the state, did the best of it not to interfere with policy matters. Actually, settlements were not allowed by the court only on private land. The court didn't interfere with the settlement policy at all. At the beginning, with the security excuse or need, the way the government told, but when it became not a matter of security, the court never decided to approve it, never, and not the opposite. They didn't deal with it, the court didn't. So I think a lot was done as much as possible. I don't know. People will feel that it's not enough. Maybe the situation is not enough good to protect human rights, but the power of the court. And again, if you ask why the right wing is against the court, this is one of the reasons. They thought that no one should touch it at all. We tried. And I believe that this is, again, although it took time, it will take time, things will be solved, but not by the court. This is not the role of the court. So this is what I can say about this situation.
Well, thank you. I would love to continue with this conversation. It's absolutely fascinating. I'm learning a lot, and I'm sure our audiences as well. But it is time for me to introduce our next speakers. Justice Beinisch, thank you so much for joining us today. If you'd like to come back for the questions, we're receiving lots of questions. It would be lovely to have you, and I also would love to invite you to come to Los Angeles at some point and speak to us here in person at UCLA at some point. It would be a real honor to host you here.
Thank you.
Thank you. So now I'd like to introduce our next two speakers, Professor Yuval Shany and Dr. Manal Totry-Jubran. Yuval Shany is the Hirsch Lauterbach Chair in International Law and the former Dean of the Law Faculty of the Hebrew University of Jerusalem. He was a member of the United Nations Human Rights Committee from 2013 to 2020, where he also served as the chair of that committee. He's a senior research fellow at the Israel Democracy Institute. He's the chair of the Hebrew University's Minerva Center for Human Rights Academic Committee, and he co-chairs the faculty's International Law Forum and Transitional Justice Program, and also heads Hebrew University's Cyber Law Program. Professor Shany is the recipient of the 2021 Gorny Prize for Academic Contribution to Israeli Public Law. Joining him is Dr. Manal Totry-Jubran. She is a senior lecturer in the Faculty of Law at Bar-Ilan University. In 2015, she was awarded the Ma'of Scholarship for outstanding Arab students from the Council of Higher Education in Israel. In 2018, she was selected by the Kalkalist newspaper as one of the 10 young promising leaders in Arab society in Israel. And in 2019, she was awarded the Gorny Prize for Excellent Young Researcher in Public Law. I'm delighted that they're joining us today.
Thank you, Dal.
Thank you.
So let me first of all begin by asking both of you for your reactions to Justice Beinisch's remarks. Is there anything that jumped out at you, or is there anything you disagreed with in her remarks? Perhaps I'll start with you, Professor Shany, and then I will turn to you, Professor Totry-Jubran, for your response.
No, I think I agree with a lot of what Justice Beinisch has said. I mean, the court is in a way between a rock and a hard place, and it is in a damned if you do, damned if you don't situation, at least vis-a-vis the political echelons and also the larger Israeli publics. So the court doesn't have clear authority to do a lot of what it does. It does whatever it does on the basis of precedents and some organic growth and some creative interpretations of its authorities. And I think it senses that there are legitimacy limits that it confronts in terms of basically taking it too far. I mean, stretching the boundaries of legal interpretation too far. And when we'll talk shortly about the nation state law, I think this is perhaps where the court has sensed that it has reached the limit, but the same thing is also true of the cases involving Palestinian territories, where you really see that the court is very much involved in mitigating some of the more brutal and harsher dimensions of the very lengthy administration, but having limited capacity to actually deal with many of the root causes. So it's more in a damage control mode than in actually engaging in more dramatic, social change kind of approach.
Thank you, Dr. Totry-Jubran.
Yes, I think that I would join both of my colleagues on what they said before, and mainly focusing on lack of a basic law on regulation that also very much affect the court's authority, and as a consequence of that, also its public trust. It's the margins that they can decide within. But I think, and there's another very important issue here, that Israel lacks a written constitution and a formal constitution on human rights. So by the end of the day, the court, especially the Supreme Court, but also lower courts, are considered as the major protecting guard of human rights. And as Justice Beinisch said before, particularly right-wing political parties, and also more religious parties. By the way, here the Arab religious parties as well can combine with these religious parties that not only politically are right-wing, but are also do not have any agenda for protection of basic human rights of women, of LGBT, and so on. So the main problem is that there is no regulative basic law that would provide the court some kind of a protection or a safeguard that would allow it to do what it's doing now. And this is why it's always under attack. And the second thing, again, is the lack of formal human rights bill. We have two basic laws that anchor basic human rights, but still, we don't have any protection of the equality value in any basic law. And this is a major problem when cases that regard a violation of equality law, whether against the Arab minority in Israel or against women or LGBT and so on. And so this very much affects also the court's authority, I guess.
So I want to follow up on that in a moment. So, I mean, it seems that both of you are kind of endorsing the point that was made at the opening, in his opening remarks by President Rivlin, and then Justice Beinisch, about the need, maybe the part of it, the solution to the challenges facing the court and the attacks against it is the passage of a basic law that would clarify and put in and codify the powers, the authority of the court and its relationship with the Knesset. In the absence of that, there's this kind of ambiguity, and that opens it to attack. And so I'd like you, if you can, very briefly, if you agree with the need to pass that. And then on the other subject of basic laws, Dr. Totry-Jubran mentioned there isn't a basic law that spells out the right to equality. However, as I understand it, the basic law on human dignity and freedom has been interpreted effectively to be, do you not think that is sufficient protection for the right of equality? Does there need to be a more explicit law, especially in light of the passage of the nation state law, which did not mention equality, did not mention democracy, And so does that now necessitate a basic law to really clarify this, the legal commitment to equality?
So maybe if I take a first attempt, so yeah, I absolutely agree with this idea that there is an urgent need for a basic law regulation or legislation, as we call it, it's not only to establish the rules of the game. I mean, you have to understand that when a country does not have a formal constitution and does not have any mechanisms that protect the norms that we call constitution basic laws from being amended, you can basically have a one vote majority in the Knesset. So if you have 61 votes out of 120 in the Knesset, they can do everything. So they basically can eliminate the right of standing to the court. They can completely politicize the court. So you're operating under the shadow of a political backlash, which is very easy to do. I mean, in the past, there were some, the court had a lot of support, so this was not really an option. But now you have parties, including, by the way, today in the Knesset, there was a passage of a draft bill, first reading, preliminary reading. It will not go very far, but basically introducing term limits for Supreme Court justices, something which, is being considered, I know, in the United States as well. But this is something that can happen in Israel, in theory, overnight, unless you have a basic law that in a way protects the constitution itself and then also protects the court. And of course, not having a Bill of Rights, having basically almost all the Bill of Rights read by the court by way of interpretation, it generates two problems. One is legitimacy, because the court is being attacked of, making up all these rights, because equality has not been introduced into the basic law. It was not an accident. People heard about equality in 1992. There was a conscious political decision not to introduce it, and yet the court read it nonetheless into human dignity. And this is still considered as a sort of a power grab by the court. But also in terms of, basic laws like the US Constitution and other constitutions, they also have an important educational value. They basically represent the identity card of the nation. And when you have an identity card without equality, this is, another very flattering identity card. And I think it does have to do, it does reflect itself in many areas of life in Israel, that the value of equality is not sufficiently inculcated. Partly, it's not the only reason, but it's partly because there is no formal acknowledgement of that value in the basic laws, which, children in high school learn when they study about, society and governance.
Dr. Totry-Jubran, in terms of the lack of the value of a law explicitly codifying equality, and in the context of the passage of the nation-state law, what kind of a threat do you think, in terms of legal rulings, in terms of the Supreme Court, have you seen any shifts since the nation-state law has been enacted in terms of how the court has ruled on issues concerning equality, and particularly concerning the rights of the Arab minority in Israel, who I think have been particularly concerned by the passage of this nation-state law?
I just have to say something about what Yuval have just, and what we talked about until now. I'm kind of a bit worried also from this legislation, a basic law, because up until now, on the other hand, the court had some sort of a space that they could work within. Okay, so I'm just troubled that a regulative basic law would actually limit the court's authority. This is just, it's really important to clarify it. It's not like it's a magical solution that will now increase the public trust in the court. And as for your question, I have to say that most of the criticism against the basic law of the nation state, Israel as a nation state, actually regards the lack of equality law and the word democracy. But what bothers me more, what worries me more actually is one very troubling arrangement that it also affect the status of the Arab minority in Israel, and I'm referring to Article 1 of the Basic Law, which states as follows: the land of Israel is the historical homeland of the Jewish people in which the state of Israel was established. Section B states that the state of Israel is the nation state of the Jewish people in which it realizes its natural, cultural, religious, and historical right to self-determination. Now, it was argued by MKs who phrased this law that it regulates the rights of the Jewish people, and what is lacking there, it doesn't have to do anything with the status of the Arabs in Israel and other non-Jewish citizens. But it actually do very much affect these groups, and not only the Jewish people. It also regulates the legal status of all Arabs living under the Israeli constitutional regime, which includes the Palestinian citizens of Israel, Palestinian residents of Jerusalem, the Syrians residing in the Golan Heights. And so this is for many reasons. The people in this statement in Section 1 are not limited to Israeli Jews, nor is it defined in terms of the state of all citizens, but rather it includes the Jewish people wherever they are in the world. So based on, and this is based on some sort of historical religious rights. And I have to say here that as a secular person, woman, I cannot relate to such a seemingly godly divine connection. And another point is that we have to think about what is the historical land? What is the history of this homeland? How far do we go back in time in order to base some sort of a historical right? And especially when we're talking about a constitutional right, because it seems, for me at least, that it is more reasonable that people who lived here 80 years ago and who some left their homes unwillingly and who actually see this space as their homeland have a historical rights, right? So it's and another issue that I find it very troubling as a citizen of as an Arab citizen of Israel is that, and specifically this statement that I refer to in Section 1, is that it's a statement about the past and also about the future. So let's take aliens that are coming out of Earth, who would read this section could never guess that there's another group living here, and there was a history of people living here who became refugees. It's kind of erases totally the historical existence of the Arab minority, their heritage, their narrative, their ancestors, and we are kind of foreigners in our homeland, right? And so it also connects to the future, because we are, by the end of the day, regarded as second-degree citizens. So it's not only the issue of equality, but it's also the issue of who are the owners or the persons who are part of this homeland.
Absolutely. I mean, certainly, I think those criticisms are very well founded on the declarative, in terms of the nation state law as on the declarative level and the statements it makes. But has it actually, I mean, Justice Beinisch suggested that it's made no legal impact, really, that the Supreme Court justices since 2000 haven't really, hasn't really changed the nature of their rulings. Is that, do you agree with that view? I mean, can we point to any specific decisions made by the court that have been affected by this nation state law, or is it really just more, symbolic, and it hasn't actually really translated into judicial rulings? Perhaps I'll start with you, Professor Shany.
Yeah, maybe I'll just say to the audience, I mean, some of them know pretty well, I'm sure, what the nation state law is, but maybe for those who haven't followed the debate as closely, I'll just say in a couple of sentences that this is a basic law that in Israel has a quasi-constitutional status. It was passed in 2018, like Justice Beinisch said. And the idea was that, well, we talked about a constitutional revolution in which the court has taken these two human rights laws and basically started striking down Knesset legislation on the basis of these laws. It hasn't done so, I mean, that many times, about 20 times. But it has the power now. Every law has to be vetted, whether it is constitutional law, whether it protects human rights. So, more right-oriented, the right-wing-oriented party decided, well, the court is pushing the discourse, the constitutional discourse, in a certain direction, which is more liberal, which is more democratic, which is more basically diluting the Jewish nature of the state, Jewish group rights in favor of equal rights to everyone. And we had some important cases about allocation of land, etc. So the idea is, let's try to swing the pendulum back by passing a basic law that would basically state what are the Jewish values of the state, so as to guide the court in the direction, basically recalibrate the constitutional discussion and guide the court to give more weight to values such as the prominence of the Hebrew language or the national ethos of Jews, to basically that the state would promote what is called Jewish settlement. This is in Israel proper, I should say, but we use the same, basically establishing Jewish kibbutz, moshav, communities, etc. But also, like Manal said, try to fend off a discourse that was very powerful among left-wing thinkers and Arab thinkers in the early 2000s, and this is that the state needs to be redefined from being Jewish and democratic to being a state of all of its citizens, which means in the Israeli context that basically there are no special attributes that render the state particularly Jewish. Everyone has the same stake. Every group and every individual has the same stake. So this is what the law actually does. In practical terms, we've started seeing a number of district court and lower court decisions that were indeed applying the law in, let's say, creative ways that were concerning, such as imposing extra compensation on terrorists because they were out to kill Jews. So they said, well, since the basic law requires the state to protect Jewish lives, and the lives of citizens, I should say, then we would require extra punitive damages. And there was a case, a schooling case in a municipality in the north where Arab students demanded that there would be a local access to an Arab-speaking school, and a justice of the peace, a very low-ranking judge, said, no, the basic law says it's a Jewish state, and therefore we do not have to dedicate as much effort, resources for Arab education. So there were beginnings of signs that could actually give some backwind in the sails of those who are promoting a very ethnocentric interpretation of the laws. Now, I should say that all of these cases have disappeared in the way that they were reversed on appeal, either before the Supreme Court or district court. So we haven't yet seen the damage, but in concrete cases. But I think, once the ideas are out there, they may find a root in various locations. Maybe I'll just close this intervention by saying the court did issue an important decision last July, which clarified the meaning of the basic law, and in a way expressed the position that the basic law is by and large declaratory. This was the position of most judges on the court. There is an important minority decision by Judge Kara, who basically said, no, it's a law that also has some operative consequences. And the court says this is a declarative, and it doesn't really tilt the balance. It shouldn't be read as tilting the balance between Jewish and democratic. It has some features. It basically puts flesh on the bones of what does it mean a Jewish state in the Jewish democratic formula, but it doesn't change the formula. And therefore, it basically helps us identify what does the legislature consider to be the Jewish aspects of the state, but it doesn't really render the democratic values of the state subservient to the Jewish state. So we have to see, we're a few months after that decision, whether this, in a way, indication by the court of how you should interpret, whether it is able to stifle out those lower court decisions that took the basic law in somewhat, as I said, the alarming directions.
Of course, some might say that the court's ruling in that, or the majority's opinion, was also a way of avoiding invalidating the basic law, the nation-state basic law, because it said, well, we don't need to because it doesn't change the balance. But Dr. Totry-Jubran, maybe you can comment on this and yes, maybe mention what the minority opinion was on this.
Yes, exactly. I'll talk about the dissenting opinion of Justice Kara, and then I will, since Yuval covered the ruling that has been given up until now, I want to present actually another aspect of my fear of the law's effect on reality and on the legal system. So, in his dissenting opinion, Justice Kara stated that the provisions of Section 1, which I discussed earlier, and 4, that regards the status of the language, of the state's language, and provision, and Section 7 about the Jewish settlement as a national value of the basic law, he stated that they deny the democratic identity of the state and rattle the foundation of the constitutional structure, and therefore the law should be null and void. For Justice Kara, the law disregards the accepted balanced formula of the state's dual identity as Jewish and democratic. He also states that the law disregards for the very existence of the indigenous minority, the citizens of the states, the Arab who are referred to as present absentee. They are present for the purpose of harming their language, and they are absent by virtue of their exclusion from the law, the exclusion of the values of equality and democracy in nation law, and all against the backdrop of lack of equality that actually exists for the Arab minority, underscore the violation of the principle of equality, which itself has not been constitutionally enriched, as discussed before, or protected. So additionally, Justice Kara also wrote that the purpose stated explicitly in the law itself of the provision concerning the Jewish settlement is what you also mentioned before, is to create an operative constitutional norm that would de facto negate the legal situation following the Qa'dan decision and the admission committee's laws, that is to deny the principle of equality in the allocation of state land and in housing, without prohibiting discrimination on the basis of national affiliation. So Justice Kara also added that the declarative reading of the law is still inconsistent with the manner in which the other basic laws are interpreted and applied. And so the nation law has operative legal implication, and this connects to your question before, such as it seems it provides constitutional protection for discriminatory legislation and discriminatory decisions that may be made under its auspice. Now, he also, and I find it really interesting, he also ended his ruling in an Arabic saying, and he also wrote it in Arabic, not an accidentally, I guess, following Section 4 of the nation state, stating that the hurt and the insult felt by the minority can never be completely understood by the majority. And so this is the background of what my concern regarding the nation state's effect on reality and on everyday. So it is really a challenge, and we will have to live and see how the court will decide upon cases that will reach the court. But I'm more concerned actually from cases that will not reach the court. I'm more concerned, as I'm a law and society research, and I specifically research mixed cities, and I am more troubled from the declaration in Afula, which is a city in the northern part of Israel, where the municipality declares that they will maintain, after their election, they will maintain the Jewish character of Afula, and de facto will try not to absorb or sell or prevent from Arab families to enter Afula. So these kind of declarations, this kind of consciousness that is provided through the basic law that can be translated into administrative decisions are very troubling, are much more harmful, and can be much more dangerous, because not all of these decisions will approach the court. When they approach the court, I'm less worried, because I hope that the court will go as it ruled in the petition against the nation law. But I'm more concerned about the situation where Arab families will not move to Afula and will not move to other Jewish localities because some sort of declarations, obvious and not obvious declarations. So the basic law, you have to understand that the basic law is telling us who is the master here, who is the owner of this place, and who decides on what. And this has a very large effect, because eventually legal decisions affect everyday life or social life. And this is the problem. This is the major effect.
Thank you. So we've spent quite a lot of time talking about laws, obviously, and the basic laws, but these laws obviously are interpreted and ruled upon by people, and the justices on the Supreme Court. And just this past week, just a couple of days ago, the Knesset's Judicial Appointments Committee appointed 4 new justices, among them the court's first Muslim justice and the first Mizrahi woman. We also have a question that's come in from Gael Tashir, who's a visiting professor who's from the Hebrew University of Jerusalem and is with us at the Nazarian Center at the moment as a visiting professor, who pointed to the fact that Gideon Saar, the justice minister, who's a right-winger and has been in the past a vocal critic of the court, appointed maybe, some liberal judges, relatively liberal, moderate judges. So how do you see the composition of the court changing? And is the court still this liberal court, or is it now divided into kind of two camps, liberal and conservative, in the way that, we've come to think of the Supreme Court? So the whole issue of who's sitting on the court, which of course in the United States is like the biggest issue, how is that playing out in Israel? How will that affect the rulings of the Supreme Court going forward?
Yes, so I think it's a discourse that we are increasingly hearing in Israel, and I think this is one of the many, perhaps not very benevolent influences that we are receiving from the United States. So I think like Justice Beinisch said before, for many years there was a perception that the judges are professional judges, they're not into politics. There are differences in style and temperament, but you really cannot divide them on political lines. And I think in the last decade, this discourse has shifted radically, and especially on the right, there is a sense that the judges are leftist. This is the Jerusalem branch of the Meretz party, which of course is a bit laughable when you look at some of the decisions on security cases, which are quite tough. So I wouldn't subscribe to that. But we have seen, especially the previous Justice Minister, Ayelet Shaked, who's now Interior Minister, she's been pushing very aggressively and openly this agenda of changing the composition of the court.
And she criticized these recent appointments.
And going out of her way when she was Justice Minister to appoint what are called conservative judges. This is the code word. So they are less enamored by the constitutional revolution and by the open doors policy and by the stability, and they actually want to roll back the court. to a more conservative outlook. I think she has been successful in appointing 3 or 4 judges of that made from that cloth, grossly speaking. Although, of course, you know, these, like in the US, there are often surprises, and there are judges that switch, and some actually one of the most activist decisions by the court striking down legislation because the Knesset members didn't study thoroughly the bill was issued by the most conservative judge on the court, Judge Solberg. So I wouldn't pay a lot of attention. I think what happened this week is interesting, that because we have this, you know, this broad tent coalition, which is really a very diverse coalition, and we didn't talk about it, but I think having actually an Arab party in the coalition and Arab ministers could be as important to signal, you know, propriety interest in the Israeli policy to Israeli Arabs as you know, some decisions by the court. So it's not only the political arena, and integration in the political arena is also very important. But anyway, we have seen basically a political deal between the Minister of Justice, who leans to the right, and the judges and the bar, who are the three elements that select judges in Israel. It has to be some agreement between judges, bar, the Bar Association, and the politicians. So he struck a deal basically to appoint 2 liberals and 2 mild conservatives. So in terms of if there was an aggressive push to change the composition of the court, that push has significantly slowed down. And the next roster of judges is going to be maybe just because we had 4 liberals stepping down, and maybe 2.5 or 3.5 liberals were appointed in their stead. So maybe there's a very slow glacial pace movement towards a more conservative, but I wouldn't, so in terms of, so I think for the right wing politicians, this has been a very, for the more hard right, this was a very disappointing outcome. So they see it as a sellout of right-wing politicians in the coalition. They were unable to basically to stop the appointment of liberal judges.
Does that mean that the right, I mean, given this disagreement between Ayelet Shaked and Gideon Saar, you know, over these judicial appointments, and the battle that took place when the government was being formed over the very formation of this Judicial Appointments Committee, which clearly shows the emphasis now. I mean, this was a fairly, I suppose, obscure committee, and now it was like the heart of the coalition, basically, agreement was really focused on this Judicial Appointments Committee. Does this indicate then that the right's campaign to change the Supreme Court, to change either its composition or its powers, is altering, and that is, in fact, there's now new divisions on the right over over what kinds of reforms are necessary? And maybe we can see this reflected in this division between Shaked and Saar.
So if it's a follow-up to me, I don't know whether Manal.
Yes, either one of you can take it.
So yeah, I think that's exactly right, and I think that's a broader question about. It's not really about the legal system; it's about the political map in Israel, which is realigning itself as we speak, and we do have now a distinction between. It's much less right-left in terms of policy vis-a-vis the Palestinian conflict, the West Bank, etc. It's whether you're taking a basically what we call mamlachti, a national interest, a broad national interest approach, or acceptance or respect, deference to state institutions, the judiciary, etc., or whether you basically think that the system is rigged. And so the conservatives are actually out for reform, for basically for revolutionizing the system. And the more right of center parties are actually, they want to introduce some more incremental, gradual reforms. And I think this is the power struggle that is taking place on the Israeli right. And Gideon Saar, the justice minister, is representing the more moderate faction. And in this particular political configuration where you have a broad coalition, they actually are able to carry the day.
I have to say here that I think that, as you just mentioned, it's part of a larger conflict of reorganizing the whole system, not only the judicial system, but also the political system. And we see that not only in the attack against the Supreme Court, we see that also regarding the attack against the gatekeepers within governmental offices, and turning these gatekeepers, professional gatekeepers, into just pkidim, Yuval, kind of a tech,
basically
clerks, like
clerks. Yeah.
Like, so it's kind of restarting the system all over again, and the judicial system is just part of it, kind of rethinking about the democratic game, and in my opinion, making it or moving it to a less democratic game of only a technical democratic game. So the majority rules, the majority says, and that's it. And there's another issue regarding the Supreme Court, is that the appointment of settler judges who the first judge that were appointed was that it was a big issue regarding the legitimacy of having a settler judge, but now it's kind of a consensus that we do not discuss anymore. It's totally acceptable and it's fine. And this goes back again, the issue that we did not talk about too much. When we talk about the democratic game, where do we position Israel as a democracy regarding the occupation that have been going on for more than 50 years? So it's a really complicated reorganization of the game that have many consequences.
Absolutely. I was, if we'd had another hour, I would have asked you all about your response to the recent report by Amnesty International alleging Israel is committing the crime of apartheid. I'm sure we would have a fascinating conversation about that, but unfortunately we don't have time. I want to give the last word and welcome back to Justice Beinisch. I hope you heard the conversation, and if there's any response to the discussion that we've had and the questions that have been posed, Justice Beinisch.
Well, I agree to most of the things that we heard now. There is, as to the law, the national basic law, I think it is a potential of, it could be interpreted in a way which will create problems of discrimination between the two populations in Israel, but I don't think it happened. I hope it will not happen. And the court, with its interpretation, will, as far as we can see for the future too, will keep the balance that we have between a Jewish and democratic state. So I'm not worried about it, but of course we cannot know what the future will bring. As to the elected new justices, I still think it's again balanced. The problem is that there is a mixture of understanding. People do not really understand. Activist and conservative is not exactly right and left, but it became, the only thing we say is if he is a right wing, he's a conservative, and if he's not a right wing, is an activist. And Yuval just gave the example that the most conservative, right wing justice, if we can label someone like that, was the most activist justice when he annulled legislation, he declared legislation annulled. So this is more complicated. To bring these labels is part of the if I may say so, the political system of the United States. We always thought that we shouldn't be in appointing judges politically, as I said before. There is a kind of political parties or members of political parties who really want to make it more political, and it was already discussed, Jaquet or others who say we need our judges. I'm afraid of it, because to bring justices that belong to our party, our government, means really to lose the independence of the court, which is the most important thing. A court cannot function if it's not a really independent court. So I'm glad that it didn't happen now with those 4 justices. It seems it's balanced. I hope so. They come mostly from the judiciary, which is very important, because actually if someone is a judge in a lower court, he is really a professional. He comes from a professional background, not a political background, and it worked well until now. I hope it will be like that in the future too.
Absolutely. As somebody in the speaking from the United States, we're just about to receive President Biden's nomination for the next Supreme Court justice, and I can tell you, I hope Israel isn't Americanized in that respect, and that the kind of politicization, the really bitter partisanship that characterizes Supreme Court appointments in the United States doesn't happen for Israel's sake in Israel. I want to thank all 3 of you for a really informative and enlightening, interesting conversation. I am sure it's been informational and informative from everybody in our audience. So thank you all so much for joining us today. And I want to thank again the Israel Democracy Institute for partnering with the Nazarian Center to put on this special program. And I hope this will be the first of many that we will put on. And finally, I want to encourage all the members of the audience to join us next week on March the 1st, next Tuesday, March the 1st, where we will be hosting a talk by Professor Shlomo Ben-Ami, Israel's former foreign minister, who will be talking about his new book, Profits Without Honor, the 2000 Camp David Summit and the End of the Two-State Solution. So I hope you will join us next Tuesday. Thank you all, and thank the speakers again very much. This webinar will be available on the Nazarian Center's website, as well as on our YouTube channel. So if you enjoyed it, please share it widely. Thank you again. Goodbye.
Thank you. Thank you for having us.